public interest lawyer Jiti Ogunye. Thank you very much for joining us. And very quickly, I would like to start with the situation in Ebonyi State. In Ebonyi State, during the week, there was this ruling by the Court of Justice Ekwo. The ruling was based on Section 221 of the Constitution, saying that, look, the party holds the mandate, and that political appointees or elected persons cannot take that trustship position and go to another political party. And this has been very controversial. There are other commentators on the subject, Chief Robert Clark, SAN, Chief Uzekome, SAN, who have all said that, look, the position of the law has since gone beyond that. Amechi versus INEC, AG Federation versus Atiku Abubakar, and some other cases. But what's your take? Because the governor of Ebonyi State himself has said that he will go to court, and that he has appealed the case, and that the court arrived at this decision by inquirium. But before I come to you, let's take this report.
In a landmark judgment, the court ruled that the votes in any election in Nigeria are to political parties, this is in quote, and not candidates. And in line with the court order, PDP is immediately submitting to INEC the names of our candidates for governor and deputy governor of Ebonyi State, respectively. In fact, that already has been done. And in line with the court order, we are also calling on INEC to immediately issue.
There is no constitutional provision for any hatchet man to remove a governor. There are three ways whereby a governor can vacate his seat. It's either by death, resignation, or impeachment by the House of Assembly. There is no any other constitutional provision that empowers a hatchet man to turn the Constitution and the law upside down. I've listened to the judgment of Ekwo, and it's very obvious that he was on a mission. He was making all efforts to upturn the rulings of the Supreme Court and Appeal Court on issues like this. We have had the rumors before now that he was determined to give judgment against all known laws.
Well, Jiti Ogunye, thank you very much for joining us on this live, this Sunday talk show. Let's start with this matter in Ebonyi State. Very controversial, and I know you've been following the story. What's your take?
Well, let me start by saying that the issue of defection or decamping of a sitting governor from the party that brought him to power and office to another political party raises a number of issues, including the morality of such a step. But since we are talking about an office that is created by the Constitution, inevitably it is the law and the Constitution that we must look to for guidance to determine whether such a defection has a constitutional implication and ultimately whether there is a consequence that is provided by the Constitution for such a step. I've read in part, and I've read the review of the judgment delivered by Honorable Justice Inyang Ekwo of the Federal High Court Abuja division. And I must say that with profound respect to His Lordship and the adjudicatory labor, obvious in the preparation and the delivery of that judgment, that the reliefs granted by the court in that judgment have no constitutional foundation or backing. There is no constitutional provision that prescribes that on the ground of defection, an executive office holder, namely the president, the vice president, the governor, the deputy governor, will have to vacate his office or be removed from office on the ground of defection. There is a provision for that if we are talking about a legislative seat. And here I reference the provision of section 68, subsection 1, G of the Constitution, and the provision of section 109, subsection 1, paragraph G of the same Constitution, are relating to a member of the House of Assembly and a member of the House of Representatives or a senator, a federal legislator. That provision states clearly that in the event of a member having been sponsored by one political party to become a member and he got elected, abandoning his party, his sponsoring party, and moving to another political party, he shall vacate his seat. But even at that, there's a caveat, there's a proviso, that if he's becoming the member of the latter party arises from factionalization, division, a national division of the political party or merger of the political party, he shall not vacate his seat. And that issue has been resolved by the Supreme Court in the case of Abegunde and Ondo State House of Assembly, which is reported in Nigerian Weekly Law Report, part 1461, in 2015, that he must vacate. That's clear. But for an executive office, there is no constitutional provision for that. There is indeed a Supreme Court decision in the notorious case of Attorney General of the Federation and Atiku Abubakar, reported in 2007, Nigerian Weekly Law Report, part 1041, that defection is not a ground for the removal of any of these four persons that I mentioned, office holder, or declaring their office vacant. So the Supreme Court also settled that. Now, I know that in this judgment, the Honorable Judge relied heavily on the case of Amechi and INEC, 2008 Nigerian Weekly Law Report, part 1080, to the effect that it is the political party that owns the votes cast. Now, the Supreme Court did that in that case because of the peculiarity of that case and because of the context. Here, a person, and I'm referring to the then candidate, Rotimi Amechi, having won the primary, was removed, yanked off the list, and Celestine Omea was substituted. And he went to court even before that was effected. And while he was in court, you know, the PDP did what he thought it had the power to do. And when the matter got to Supreme Court ultimately, by which time Celestine Omea has been elected and inaugurated as a governor, the Supreme Court reached for the mandatory injunction device to say, no, you can't do that, and then to rule that those votes were indeed for the party. Not only that, that in the eye of the law, Celestine Omea was not the one who was contesting, that it was Amechi. Now, the court relying on that case, in my view, is an error. Because that case, the decision of the Supreme Court in that case, has suffered two effect suffered two underminings, essentially. First, following that decision, the legislature in the now repealed Electoral Act 2010, and there's a carryover of that provision to the current version of the Electoral Act, the Electoral Act 2022. This legislature amended the Electoral Act, and in section 141, it provided that no person could, in any circumstance, I'm using the words of the provision, could be declared as having won an election if he had not participated in all the stages of the electionary. In other words, the section that the case of Amechi that the judge relied on had been superseded by legislative intervention by way of arresting that decision. But that's not all. In the case of CPC and Ombu Gadi, I reported in Nigerian Weekly Law Report 2013, in part 1383, part 1385, by 1385, the Supreme Court acknowledged in that decision that the decision of Amechi and INEC had been cancelled, had been repealed by the legislators in the section 141 that I just referred to. So for the honorable judge to now in 2022 travel back to 2007 to the case of Amechi, which had a specific resonance, which had a specific import, for that purpose to then use that to adjudge the matter as he had adjudged it, I think that there's a problem with that. There are other issues, related to that judgment, including the issue of multiplicity of action, because there had been a decision in Ebonyi State affirming that the governor could continue to be in office. Although I understand that the case that was filed in Abuja, which Milord decided, which we are discussing, was filed first before the Ebonyi case. But the decision in the Ebonyi case, came first. And so essentially, what we are now discussing is a conflicting two judgments on the same subject matter, by cause of coordinate jurisdiction, which has again raised the issue of whether our courts can handle this matter without having this kind of conflict. As I said, there are other issues related to the judgment, but these are the ones I'm willing to quickly say just now. So my view is that, and this is not playing an appellate court, the court delivered a judgment. If parties are dissatisfied with that judgment, they have a right of appeal, which is a constitutional right. They can bring an application for stay of execution. If it is not a declaratory judgment, it is an executory judgment. And if it is not, then they can just bring an appeal and ensure that everything is done so that a higher court can determine that. However, I was wondering why it wasn't possible for the party that lost the case in Ebonyi to appeal the matter to the Court of Appeal, so that we won't be having this spectacle of having two conflicting judgments, as it were, on the same subject matter. So it is beyond argumentation. Lawyers argue a lot. It is their forte to argue. But given what the state of the law is as of today, the office of the governor cannot be declared vacant on that score. I understand, however, that the judgment extends to other members, of the party, the legislators who also defected. And in my view, given the case that I've just cited, the case of Abegunle and Ondo State House of Assembly, I think that those ones, the persons in those categories, are not the governor and the deputy governor, have a cooling task, uphill task to succeed on appeal. But for the governor and the deputy governor, I think that judgment is not in line with the decisions of our court on the subject.
Okay, thank you very much. I get the point that this would seem, with regard to the governor and the deputy governor, a violation of established laws, stare decisis, precedents, but it doesn't apply to the 16 members of the House of Assembly. And in that regard, maybe perhaps the Federal High Court of Justice Ekwo may have arrived at this ruling with regard to Umahi and his deputy per inquiry. But what do you think, which is related, of Section 308? Because the point has been raised that the governor and the deputy should not even have been sued in the first place, because the issue involved relates to their personal capacity rather than civil or criminal proceedings. And that why is the PDP cherry picking? They didn't find the need to do so in some other instances, but the party found the need to do so in the case of Ebonyi.
Now, let me say this. My fundamental reservation about that judgment regarding your line of question is that, look, this is not an election petition. This is not a case of a pre-election matter. We are already talking about tenure of a governor now that is almost being wound up anyway. And so, where will the court derive the jurisdiction to then adjudicate on that issue and say, INEC, should receive a list of new nominees or fresh nominees or substitutes, and then, conduct a fresh election. I mean, it's not an election petition. It's not a pre-election matter. But to answer your question directly, sir, Section 308 is the immunity clause. In a number of cases, including the case of Tinubu and IMB Securities, it's been decided by our courts that once somebody is clothed with immunity, an executive of under Section 308, he can be sued to court. Summons cannot be issued against him. But he can sue. So it's like a shield. He can sue in respect of personal action like defamation and all that. But he can be sued. Now, in the case of Amechi and INEC, the Supreme Court discussed the point, because that point was raised, that Celestine Omia was already in the saddle. He was already a governor. I think that it was Gassama San that raised that issue, and that it was therefore covered by Section 308. And the way the Supreme Court responded to that was that in election and election-related matters, I'm quoting the exact wording of the judgment, that Section 308 could not be invoked to shield a governor from answering to a case that had to do with how he became a governor. Now, in this particular case, the Ebonyi case, Section 308 could be invoked. But my view is that that provision was already discussed in the case of Amechi that the judge relied on. And I'm not therefore surprised that because of the way the Supreme Court treated the issue of Section 308 in that decision, and Honorable Justice Ekwo was relying heavily on the case of Amechi and INEC, he wasn't going to have any truck with Section 308 stonewalling or argument on the issue of whether he had jurisdiction to determine the case that the way he had determined it. Now, for me, Section 308 may not be too strong on this issue we are discussing. But what is very strong, as strong as the Rock of Gibraltar, is that there is no constitutional provision. And you cannot imply it. In the case of Obi and INEC, I think it was Justice Adiremi who made the point that, look, the duty of the judex is not to imagine what is better, what the Constitution ought to have provided, and therefore, supplementing or improvising. No, you interpret the law the way it is. And I am saying that there is no constitutional provision that supports what
very clear.
Honorable Justice said.
Very clear.
Section 221 of the Constitution. Section 221 of the Constitution is about, is about political parties. And it merely provides that, yes, the Constitution recognizes right to freedom of association, you can form an association and all that. But that no association that is not registered as a political party could participate in an election or field candidates. Okay. So it was surprising that it was that section that has nothing to do with the subject of adjudication that the court rely on to arrive at his decision. That section has no bearing at all on whether, on the ground of defection, a governor could be asked to vacate his office.
I get your point clearly. Austinian positivism, the law, is what the lawgiver says it is. But in our jurisprudence, we've also had cases of judicial activism from Lord Denny to the president. Yes, exactly. But we don't need to start that now. But I just wanted you, before we go on, to comment on the position of the Senate on Section 84(12) of the Electoral Act, which the President of Nigeria said should be reviewed, should be re-amended. Very briefly, because we need to come back to the panel in the studio.
Now, okay. Well, my view is that the National Assembly acted rightly in rebuffing the President on two grounds. First, an epistolary, communication is not the constitutionally recognized platform for seeking an amendment of a law. If the President desired the amendment of that provision, Section 84(12), he ought to have quickly sent in an executive bill, which would then lead to the amendment. But what he did was he wrote a letter and he provided reasons. That could have been the way it had always been done. There could have been a quid pro quo, but I am insisting on the right constitutional part, and the President didn't do that on this occasion. The second issue is that, for me, that provision that has become controversial is well grounded. Section 223 of the Constitution provides that the Constitution and rules of a political party shall provide for a periodical election on a democratic basis, emphasis, on a democratic basis of the principal officers and members of the executive committee and other governing bodies of a political party. How can you have a situation in which political appointees, whose number are indeterminate? There was a government in this country that had 200 special advisors. So if you are going to have a convention of a party to which he belongs, he brings all those advisors there as automatic electors to swamp the convention. How can that be democratic? How can that be democratic? So for me, what the National Assembly has done in stating that except before a particular day they had a resignation that they shouldn't participate in their convention as delegates or as person to be voted for, I think that's in order. And regardless of the fact that the Constitution has provided 30 days to an election, and those provisions are there, Section 66,
137, 107,
Section 107, and so on and so forth. Except that, regardless of the fact that those provisions are there, I'm saying that what the National Assembly has done is in order, and I think that the President should act accordingly. I'm miffed, though, that along the line, maybe partisans apprehended that there would be a kowtowing to what the president was demanding. So people rushed to a Federal High Court to get an injunction. And incidentally, it was also Justice Inyang Ekwo that gave an interim order, saying that the National Assembly should not look into it. That's interference. No court of law, and that issue has been settled recently. No court, when the Electoral Act before now, was also brought to the court. No court of law competently can ask the legislature not to do its job, and vice versa. So the order that, the matter is sub judice, so the matter is now be taken to court, legislature will not do anything. That's not how you govern in a democracy. And I think that each branch of government, each arm of government must respect this eternal principle that you do not interfere in their internal working and then hamstring them and then say they can't continue, they can't consider a legislation, they can't amend it. They can amend it. They made it, they can amend it at any time. But the business of the court is to use the power of judicial review after an amendment is done to say, hey, look at this provision. Use the blue pencil rule. This one is not in accordance with the Constitution. I strike it out. This one is not in accordance with the Constitution. I strike. That's the business of the court, not to impede the process of amendment while that is yet taking place. That's not the jurisdiction of the court.
Brilliant. Very brilliant submission. Thank you very much, Jiti Ogunye, for joining us on this Day Live, this Sunday talk show today. Thank you very much indeed for honoring our invitation.